Congratulations on making it to the first session, and welcome to this 4 New Square Professional Liability Day. We hope that you'll have an interesting and informative day, as well as an opportunity to catch up with old friends and perhaps to meet members of chambers whom you might not have worked with before. At the bar, we have the benefit, not usually available to solicitors, of being instructed both by claimants and by defendants. Indeed, I should say we have a duty to accept instructions from either claimant or defendant. So that means there's a mix today of claimant solicitors, defendant solicitors, and insurers, which we hope will make for a balanced discussion. This session is on limitation, and I always like to think of limitation as the gift that keeps on giving, because there are more problems that crop up every year. I think there's been more litigation on the Limitation Act 1980 than almost any other statute in the last 40 years, certainly at Court of Appeal and Supreme Court, House of Lords level. The most interesting recent developments have been in relation to Section 32, postponement of limitation, and Anthony Jones and I are going to look at these developments. I was wondering why there's been so much litigation in this field, and I think perhaps there are two reasons. One is that the Act is in some parts not particularly well drafted, which of course always gives room for lawyers to argue about it. The other is the two starkly conflicting policies which underline the Act. One is an aversion to stale claims being brought. This was highlighted, interestingly, only last week by the Court of Appeal in a case called THG and Zedra Trust, where the court held, contrary to received wisdom, that claims for unfair prejudice petitions were subject to a limitation period. And the court quoted a number of authorities, dicta, about the importance of banning stale claims. The one I thought most interesting was Lord Sumption. And the reason I found it interesting was because it came from a dissenting judgment, but nevertheless, Court of Appeal thought it worthy of repeating. And what he said was, limitation reflects a fundamental and all but universal legal policy that the litigation of stale claims is potentially a significant injustice. Delay impoverishes the evidence available to determine the claim, prolongs uncertainty, impedes the definitive settlement of the parties' mutual affairs, and consumes scarce judicial resources in dealing with claims that should have been brought long ago or not at all, unquote. So that's one policy. But the policy pointing in the opposite direction is the need to allow a fair opportunity for claims to be brought. And that's particularly the case where it said that the defendant is responsible for the claimant not being able to bring the claim sooner. The function of the Act is to strike a balance between these two conflicting policies. Section 14A, latent damage, and Section 32, which we're going to look at, are the two parts of the Act which address the second policy whilst also having regard to the first. Now, on an application to strike out, we all know that the claimant will talk about the injustice of a perfectly good claim being barred by some arbitrary rule, so that if it was brought one day earlier it would have been okay, and brought one day later it isn't. And equally, we'll know that the defendant will focus on all the many dicta in the higher courts about the undesirability of stale claims being brought. But how should the courts approach it? And the answer was given particularly clear form in the case of Howard and Fawcett's, which was a professional negligence claim against accountants that went up to the House of Lords in 2006. It was on the meaning of latent damage. And quoting from Lord Scott, he said, "The Act represents Parliament's attempt to strike a balance between the interests of claimants in being able to seek compensation for their losses and the interests of defendants in finality." And then he said, "It is the task of the judiciary to identify from the statutory language the balance that enactment has endeavoured to strike and to endeavour to apply the enactment accordingly. It's emphatically not the function of the courts to strike their own balance, whether as a response to the apparent merits of a particular case or otherwise. So what that means is that the judges, despite the blandishments of counsel on either side, should simply look at the Act and construe the relevant statute and try and give effect fairly to Parliament's intention in that section in the context of the Act as a whole. So, doing what we've been told to do, we need to break down Section 32 into its constituent parts. And we see there are three categories. A is fraud, B is deliberate concealment, and C is mistake. And we'll look at each of those, but focusing particularly on deliberate concealment, which tends to be the most relevant to our area of practice. We then need to look at the very important closing words which postpone the running of time. And we note that those words are common to all three cases and should therefore, one would have thought, be construed in the same way in relation to all three. And this is important because it means that cases on some of the more arcane areas, such as mistake, are really important and helpful in deciding, making decisions in relation to deliberate concealment. So I'm going to deal with A and B, and Anthony will deal with C and with the closing words. We'll try and allow time for questions, but do please feel free to put your hand up if you'd like to ask a question as we're going through it. So before we get to the particular words themselves, it's helpful to understand where Section 32 comes from. It originated in the equitable principle that the statute of limitations should not be used as an engine of fraud. What that came to mean is that if you had a claim that was based on fraud and the claimant, the plaintiff in those days, couldn't reasonably have discovered the fraud, then time in equity shouldn't start to run until he had discovered it or had a reasonable opportunity to do so. And by analogy, the same applied where the claim itself wasn't based on fraud, but it had been fraudulently concealed. And then the third step was that some judges thought, although this was more controversial, that there was a close analogy between mistake and fraud, and therefore the same rule should apply to cases based on mistake. But that was always more controversial, because whilst the defendant could be said to be morally responsible for the fraud, for the concealment, there wasn't the same in the case of the mistake. So those three grounds were codified in the Limitation Act 1939, and that was carried through to the 1980 Act, largely untouched, save for an important change which we'll come to in relation to concealment. It became deliberate rather than fraudulent. So I can take the first category quite briefly, and that is ground A. The action is based on the fraud of the defendant. And the courts have laid down a clear rule. A claim cannot be said to be based on the fraud of the defendant unless fraud is an essential ingredient in the claim itself. And that sets the tone for the construction of the entirety of Section 32. It's quite a narrow construction. So we then have to look at the claim and say, is fraud an essential ingredient? Well, the obvious example is deceit, fraudulent misrepresentation. There, fraud is clearly an essential element. But if you take a tort like conversion, that's often based on dishonesty or fraud, but it doesn't have to be. And therefore, Section 32(1)(a) does not apply to claims based on for conversion. Equally, it does not apply to equitable fraud. Equitable fraud is a whole topic in itself, but basically it's defining cases like Nocton and Lord Ashburton as cases where a fiduciary or person who has a higher duty in the first place, a fiduciary duty, commits a breach of that duty, often intentionally, although not always so, but even if it's intentional, it's not necessarily dishonest. Therefore, equitable fraud does not fall within subcategory A. So that's the interpretation of A. Then we come to the B, the more difficult and important one. Any fact relevant to the plaintiff's right of action has been deliberately concealed from him by the defendant. So we need to start by relevant to the plaintiff's cause of action. And that's treated in much the same way as ground A. In other words, it must be a necessary ingredient of the cause of action. It's not sufficient simply to say this particular fact is something which makes it more likely that we will succeed in the claim. So the takeaway message there is that if you're acting for a claimant, you need to make sure, if you think you might have to rely on ground B, you need to make sure that the facts which you say were deliberately concealed are stated loud and clear in your particulars of claim, and you also need to be able to justify them as being necessary facts. And conversely, if you're acting for the defendant, you'll be checking whether the facts have actually been pleaded, and if so, did they really need to plead them, or was it gratuitous? As I mentioned, unlike the 1939 Act, which talked about concealment by fraud, the 1980 Act instead uses the phrase deliberate concealment. This means that, at least in the case of ground B, it's dangerous to look at pre-1980 cases because they'll be about fraud. And it's even more dangerous to look at old cases that predate the 1939 Act. So this was something that came up in the important case of Sheldon and Outhwaite. One more. There we go. So Sheldon and Outhwaite was the first case, I think, that went up to the House of Lords on deliberate concealment. And the issue there was an interesting one, which was what happens if the facts, the relevant facts, are deliberately concealed, not at the outset, but during the course of the limitation period, after time had started to run. Two of the judges in the House of Lords said the wording of ground B is clear, and there's nothing which prevents it from applying to a subsequent concealment. In other words, if halfway through, or even on the day before the 6 years is up, to take an extreme example, there is a deliberate concealment, that stops the clock. Oh, sorry, it suspends, it means that you restart the clock once the claimant finds out, or could with reasonable diligence have found out, and you end up with a completely new 6-year period. That was what two of them said. The other two thought that couldn't possibly be right, and they reached the opposite conclusion. And the fifth one said it was all ambiguous, and he actually preferred to say that time was suspended rather than stopped, so that it then carried on, which I have to say might seem to make more sense, but it wasn't an option that was open on the natural interpretation of the words. So he ended up agreeing with the first lot, and therefore by a 3-2 majority we now have this rather odd rule that if there's a subsequent concealment, that the clock is restarted at the end of the concealment. So this is an interesting illustration of how difficult Section 32 has proved to be to construe, and how it's often been considered by the House of Lords and by the Supreme Court on numerous occasions over the last 40 years, and frequently with dissenting judgments. Also, I think some of the longest judgments that the Supreme Court has ever given. The interpretation of ground B received its biggest shake-up in November of last year, when the Supreme Court gave judgment in Canada Square and Potter. The facts can be stated quite briefly. It involved really something quite shocking. It was about payment protection insurance, PPI, and about excess commissions. And what happened was Mrs. Potter enters into a loan agreement with a lender. She borrows £17,000, but she's required to take out a policy protection insurance for £4,000 on top. And of that £4,000, the princely sum of £182.50 is used, goes to the insurer, and the rest goes to the lender by way of commission. So it really is quite shocking on its facts. That happened in 2006. Loan is repaid in March 2010, and as we'll see, that proves to be the relevant date for limitation purposes. So the underlying law, which you need to understand in order to see the limitation point, it derives from a case called Plevin and Paragon in 2014, where the Supreme Court held that very high commissions, which were charged in cases like this, constituted an unfair relationship for the purpose of the Consumer Credit Act, and that was a statutory tort under the Act, under section 140A, and that meant that the borrower had a statutory right to claim damages. The limitation period was held in a later case called Smith and Royal Bank of Scotland to be 6 years from the end of the relationship. So the relationship ended in March 2010, therefore the claim should have been brought by March 2016. It was actually brought in 2018. Firstly, Mrs. Potter received some compensation from the FCA under their redress scheme, and then at the end of 2018 she instituted proceedings, and the only issue was limitation. She had a perfectly good claim subject to limitation, and the question was the claim barred some 6 years after the unfair relationship ended? The case was first heard in the County Court by Murray Rosen KC of these chambers, and I'm glad to say he was upheld by the Supreme Court. He found in her favour. The lender appealed unsuccessfully to the High Court, unsuccessfully to the Court of Appeal, and then finally to the Supreme Court. So this case went all the way up in small stages. And at Court of Appeal level, 3 questions were decided. The first one was, does the Consumer Credit Act unfair relationship qualify as a breach of duty, which comes within the scope of section 32 subsection 2, and the answer was yes, it did. Was the non-disclosure deliberate concealment? And the answer was yes. And the reasons given, which we need to look at, were firstly, deliberate concealment is made out whenever a defendant fails to discharge a duty to disclose a fact, and that the duty does not have to be a formal tortious duty, but the duty to act fairly, which lies behind the prohibition on unfair relationships, was good enough. So that gave rise to a rather difficult question as to what is a duty if it's not a strict legal duty. Does a moral duty count? Is an unfair relationship sufficient, and what makes it unfair? And then there was the question of what's meant by deliberate, and it was held by the Court of Appeal that it's sufficient if the defendant realised there was a risk that it had a duty to tell and deliberately or recklessly failed to do so. So that gave rise to a question whether recklessness was sufficient. At the Supreme Court level, there were 2 important questions. One is, what's the meaning of deliberate concealment? And that includes the question whether this requires there to be a duty of disclosure, and is a reckless failure to disclose good enough? And the other question is whether recklessness is enough for the purposes of subsection 32(2), which is the deliberate commission of a breach of duty. On this particular occasion, the Supreme Court was unanimous, and the judgment was given by Lord Reid, the President of the Supreme Court. And he began by analysing the meaning of the word concealment as a matter of ordinary English. So this was a word that had been extensively examined by the House of Lords back in 2003 in the case of Cave and Robinson, Jarman and Rolfe. Now that was another professional negligence case, a lot of them are, where a solicitor was asked to draft a document that would give rise to mooring rights, create mooring rights for a client over a third party's land. And some years later, the third party told the claimant that the rights were ineffective. And he wrote to his solicitor about it, but he got no answer. He then sued the solicitor for negligence outside the limitation period, and he tried to rely on ground B, citing the solicitor's failure to answer his letters. But the problem he had was that it was clear on the facts that the solicitor's mistake was pure negligence. And there was no evidence that his failure to answer questions later was because he realised that he'd made a mistake. He was simply incompetent. So Lord Millett, who gave one of the two leading speeches, he confined deliberate concealment to active concealment. But Lord Scott, who gave the other leading speech, extended it to acts or omissions, provided the concealment was the intended result. Of the other three judges, two of them rather unhelpfully did what concurring judges usually do, and they agreed with both. So we were not much further forward. Lord Millett also added a powerful dictum on the importance of the Limitation Acts. He said it was neither just nor consistent with policy of the Limitation Acts to expose a professional to a claim for negligence long after he had retired from practice and to cease to be covered by indemnity insurance. And that's a point that gets echoed in Canada Square. So in Canada Square, Lord Reid agreed with Lord Scott's view that concealment includes both positive acts of concealment and withholding of relevant information. And he illustrated this with some homely examples. One example is an elderly woman who is afraid of burglars, and she might conceal her pearls before going to bed. Another is a person, here we're gender neutral, who uses concealer on their face so as to hide a blemish. Another is a man who's diagnosed with cancer, who decides to conceal this from information from his family. In none of these cases is there any duty to disclose, but those are all acts of concealment. He then looked at a trio of Court of Appeal cases culminating in Canada Square itself, where the courts had embellished ground B beyond that very simple meaning in all sorts of ways. And he ended up by restating ground B. Let's go back to it. Restating ground B with the glosses which the Court of Appeal had put on it. So it now read, any fact which to the knowledge of the defendant was relevant to the plaintiff's right of action or to a potential right of action, or as to the relevance of which to the plaintiff's right of action or potential right of action, the defendant was reckless, has been deliberately concealed by the defendant, knowingly or recklessly, in breach of a duty either imposed by law or arising from a combination of utility or morality to disclose it. Well, that, as you can see, is a complete nonsense, makes complete nonsense of the section itself. So what he was saying was the courts have added all sorts of requirements to the simple wording of B. They've added a requirement that the facts are, the defendant must know the facts are relevant or must be reckless as to whether they're relevant, that the concealment must be knowing or reckless, and that the duty to disclose must includes a moral duty, whatever that may mean. So this involves giving with one hand and taking with the other. In one sense, the courts have added all sorts of extra requirements, and in another sense they've tried to mitigate those requirements by extending it to recklessness. But the correct meaning, said Lord Reid, is that concealment does not require any pre-existing legal duty to disclose, nor is there any requirement that the defendant should know that the concealed fact is relevant to the cause of action. Concealment simply means hiding information, whether or not that information is due to the claimant and irrespective of motive. So that's concealment. But concealment is qualified by deliberately. And deliberately, again, Lord Reid said means what it says. It's limited to knowing concealment, and it does not include recklessness. We need to understand here what's meant by recklessness, because it's a term that's often misused. Lord Reid is using recklessness to mean having actual knowledge of the risk and acting unreasonably in running that risk. It's important to stress he's not using it to include willful blindness, which is sometimes called Nelsonian knowledge. And that, of course, is treated as a species of knowledge and is not recklessness. So there are only three requirements in order to satisfy ground B, and they are a fact relevant to the claimant's right of action, the concealment of that fact by positive concealment or withholding of information, and an intention on the part of the defendant to conceal the fact. So that's section 32(1)(b). 32(2) is an extension of 32(1)(b), deliberate concealment of a breach of duty in circumstances in which it is unlikely to be discovered for some time amounts to deliberate concealment of the facts involved in that breach of duty. Now, there's actually not as much room as they used to be thought for section 32(2), but it still has a role to play. There are some cases where it may be difficult for the claimant to establish that the concealment was deliberate on the part of the defendant. And the reason for 32(2) is to provide an alternative route for the claimant. Instead of having to prove that the concealment was deliberate, it's sufficient to prove that the defendant knowingly committed a breach of duty. And Lord Reid, unsurprisingly, said that deliberate in 32(2) had the same meaning as it did in 32(1)(b), and it did not include recklessness. And finally, Lord Reid raised a practical consideration, which is very important for in the professional negligence field. He noted that lawyers frequently give advice on difficult points of law or construction, knowing that these might prove to be mistaken, in much the same way surgeons frequently perform difficult operations where there's a risk of failure. And he said if deliberate included recklessness, then professionals would potentially be exposed to claims for an indefinite period, possibly long after they've retired and ceased to have insurance. That situation would imply that the architecture of section 14A of the Limitation Act, latent damage, would be irrelevant because you could always rely on deliberate concealment. And the Supreme Court's decision to cut off those arguments provide welcome clarity. At the same time as judgment was given in the Canada Square case, the Privy Council, with the same constitution, also gave judgment in the Primeo Fund case. I have to say it's just as well that no limitation period applies to judgments of the Privy Council, because it took them more than 2 years to produce that judgment. This was a case arising out of the Madoff scandal, where Primeo was a Cayman Islands investment fund which had invested in one of Madoff's Ponzi schemes, and the fund brought claims against the former custodian, HSBC, for breach of contractual duties, and also against the former administrator, the Bank of Bermuda, for breach of duties of care and skill. The case raised a wealth of questions which are outside the scope of today's topic of limitation. But the limitation point was as follows. The Cayman's limitation law, section 37, is fortunately in exactly the same terms as our Limitation Act, and the issue before the court was about deliberate, and not surprisingly, the Privy Council came to the same conclusion as they did in relation to in relation to the Canada Square case. The Court of Appeal in that case had got it right in the Cayman Islands. They'd done rather better than our Court of Appeal, and that was upheld by the Privy Council. With that, I'll hand over to Anthony.
Thank you very much, David. So, going back to section 32 of the Limitation Act, the third limb of this hideous animal is ground 32(1)(c), which applies to claims which are claims for relief from the consequences of a mistake. But what is meant by mistake? This was something which was considered by the Supreme Court in the franked investment scheme group litigation, which had a number of rounds and is now quite historic. The claimants in that group litigation were taxpayers who brought a claim in a restitution against HMRC. They'd made payments of tax under provisions which were eventually held to contravene EU law. In some cases, the tax had been paid 25 years before the relevant European Court ruling, which found that the provisions under which it had been paid were unlawful. And one of the many issues in the litigation was whether taxpayers could rely on ground C, the relief from the consequences of mistake, in bringing the claims which were at that point so historic. So in the first franked investment scheme case to reach the Supreme Court, it was confirmed that a claim won't fall within subsection C unless mistake is an essential ingredient of the cause of action. And that's going to be a relatively narrow class of cases. It includes a restitutionary claim for unjust enrichment to reverse a payment made under a mistake, because mistake is a sine qua non of that cause of action. A second species is going to be claims to set aside a contract based on mistake, so actual set aside for mistake claims. But the claimants in the franked investment case were seeking to recover money under the so-called Woolwich principle, which permits restitution of money which is paid under an unlawful demand. And the question was, does that count as a mistake? Is near enough good enough for these purposes? The claim was based in an assertion of unlawfulness, not mistake. And the question was, could it fall under ground C? Now the answer was no, but could the case be reformulated to be pleaded as based on mistake? Well, only if a mistake of law counts as a mistake for the purposes of section 32(1)(c. And that required a determination that the legal basis for the payment was in fact wrong. That in turn required the question to go to the Court of Justice for the European Union, or the ECJ as it then was, and the answer came back 8 years later, which was, yes, it is unlawful, and therefore it's been paid under mistake of law. The Supreme Court unsurprisingly said, well, if it's a mistake of law, as now belatedly confirmed, it does qualify as an action with an essential ingredient of mistake, and therefore the running of time will not start until section 32(1)(c) is satisfied. But the problem that the Supreme Court faced in coming to that conclusion was this problem. The common law had been changed in 1998 by a decision of the House of Lords holding that a claim for restitution could be brought in respect of money paid under a mistake of law. So mistakes of law were first recognised as capable of founding restitutionary claims in 1998. But that post-dated the language in the Limitation Act 1980. Could it be right that the effect of a common law change 18 years after this provision is baked into the wording of this provision? The House of Lords had previously held on 2 occasions that ground C did extend to mistakes of law, but the reasoning in both of those decisions was considered by the Supreme Court in the franked investment scheme action not very helpful. So the Supreme Court revisited the question sort of afresh when it considered this point in the franked investment scheme case in 2020. And the majority concluded that a mistake of law should be included within ground C, because that is consistent with the overall legislative policy of extending time where a claimant did not know and could not reasonably have known the circumstances giving rise to the cause of action. What the Supreme Court is saying is, notwithstanding the fact that it is just happenstance that mistakes of law now count as mistakes with a capital M for the purposes of our common law, in 1980 when this provision was being enacted, the whole point was, if claimants are doing their best and cannot know of a key ingredient in their claim of mistake broadly conceived, then they should not be punished for that fact that they have no control over. And it's consistent to extend the protection of section 32(1)(c) to situations of mistakes of law in the same way that a 1980 House of Lords would have extended it to mistakes of fact. Now, in the professional negligence context, this kind of case is going to be unlikely, and that's shown by Portman Building Society. That's an illustration of the narrowness of subsection C in the context of professional negligence. That's a case where a lender sued a solicitor for having advanced loan money without authority to do so. Now, of course, this was really a claim for negligence, but because the claimant solicitors knew they were out of time, the solicitors in council had dressed it up to say that the payment had been made under a mistaken belief induced by the solicitor's misrepresentation. The Court of Appeal held that that's not really a claim characterised as a claim for relief from the consequences of a mistake. It's a claim in professional negligence, and the word mistake has been put on the pleadings to get a limitation advantage. In the first place in that claim, the transaction was effective as a transaction. It was not a transaction that was going to be set aside for mistake. It was a transaction which had occurred, and the person had lost money, could not get it back, and was suing their advisor. And the second reason why it didn't count as mistake is that the negligent solicitors weren't personally enriched by it. It wasn't a mistake of law, it wasn't a sort of undue payment to them. It was just a plain vanilla professional negligence claim where some ingenious lawyers had thought of a way of expressing it with the language of mistake. That's not good enough. Mistake has to be an inherent element of the cause of action, whether that's mistake of fact or mistake of law or one of the mistake adjacent doctrines in restitution. So that's section 32(1)(c), payments, section 32(1)(c), causes of action for the consequences of mistake. Now, all of section 32(1)(a), (b), and (c), if you satisfy those subsections, you get to start the clock again. As we heard, that's not necessarily a rational outcome, but it's the outcome that the Supreme Court says occurs. But what starts the clock is the question. So section 32(1) concludes with the words, "The period of limitation shall not begin to run until the plaintiff has discovered the fraud, concealment, or mistake," as the case may be, so that's A, B, or C, "or could with reasonable diligence have discovered it." So what counts as discovering, or what counts as being in the situation of being reasonably diligently able to discover? That wording was considered by the Supreme Court in the second franked investment case. It was considered in the context of ground C, but it's of wide application, as has subsequently been confirmed by the Court of Appeal. The majority in that case held that time starts to run where the claimant knows of the mistake, and we could read for mistake the deliberate concealment or the fraud, or where they could, with reasonable diligence, know that he'd made a mistake in the sense of recognizing that a worthwhile claim arises. Now, the burden of proof is on the claimant to show that he did not know and could not, with reasonable diligence, have found out sooner. Supreme Court makes clear that this test is could and not should. So it's a heavy burden for the claimant to discharge. The standard of reasonable diligence is how a person carrying on a business of that kind would act if he desired to know whether or not any of the three grounds applied. It's to be assumed that the person in the situation of the claimant has had adequate but not unlimited staff and resources and is motivated by a reasonable but not excessive sense of urgency. So the paradigmatic claimant here is someone who is consciously thinking of the limitation consequences of the situation that they're in, taking conscious and diligent steps to discover the problem, and is thwarted by either the actions of the defendant or actions outside their control. Now, those assumptions about being adequately resourced and reasonably diligent, that factual matrix of assumptions can be displaced, as we see from the Court of Appeal case of OT Computers, in the particular circumstances of a claimant. But that's the general background. Now, OT Computers is an interesting case, which tells us two things. In that case, the claimants brought a claim for damages against defendants who'd participated in an unlawful cartel. The claimants were relying on ground B, deliberate concealment, and the issue was when they could, with reasonable diligence, have obtained the relevant knowledge of the anti-competitive actions. First, in OT Computers, it was confirmed that the trigger of reasonable discoverability, is going to be the same for all of the subsections of Section 32. That stands to reason. It's a perfectly sensible conclusion, but it's nice to have it confirmed by the Court of Appeal. The more interesting conclusion of the Court of Appeal was it held that Section 32 requires the court to, sure, adopt an objective standard in respect of due diligence, but the standard has to be one which is appropriate for the circumstances of the actual claimant. So when they say objective standard, what they really mean is a mixed subjective-objective standard. The reasonable actions of the person who's in the sort of situation that the actual claimant is in. And in that case, OT Computers, the claimant, was a company which was in administration and no longer carrying on a business. It didn't have any officers to go ferreting around for relevant information. It didn't have any employees other than its administrators, who understandably had other more pressing concerns. And therefore, the court said it shouldn't be judged as if it was still an ordinary business with adequate resources to go chasing down possible sources of information. So what reasonable diligence required was less onerous for a company in that circumstance than a company that was operating perfectly normally. I was going to say sensibly, which is very pejorative, but perfectly normally. A different issue under Section 32 came before the Court of Appeal in a case called Gemalto Holdings and Infineon Technologies. Now, that case involved a claimant who was still in business, still a functioning business. And the question was whether it could, with reasonable diligence, have brought proceedings sooner against the defendant Infineon. The court held that the relevant date for the purposes of Section 32 was the first date on which the claimant could reasonably have pleaded a claim which would not be struck out. So what does that mean? That's the date when the claimant first knew there may have been a cartel, first knew there may have been uncompetitive behaviour, and who the participants in that behaviour were. That's when the claimant knew enough to advance a claim. It didn't have to know chapter and verse how everything was operating. It didn't have to be able to particularise everything perfectly. It just needed to be able to advance a claim which would not be defeated by a strikeout for lack of particularity. So that's the yardstick. Do you have enough of a claim to be able to advance it with a straight face? If you do, you know enough for the time to begin to run. And you can't keep sitting back saying, well, our claim would be improved if we knew precisely the quantum of damages or precisely the number of co-conspirators or what have you. The time is already running under Section 32 before you as a claimant perfect the information matrix. Now, mindful of the time, I think I'll skip to one final point, which is the closing words of Section 32.1. Section 32.1, and we might as well skip back to it to give a sense of circularity to our presentation. The final words are references in this subsection. We haven't even put it there. References, so this is a little Easter egg for those in the room. References in this subsection to the defendant include references to the defendant's agent and to any person through whom the defendant claims as his agent. One of the issues in the Privy Council case of Primeo was whether Madoff Investments was acting as an agent for HSBC when it purported to comply with various sub-custody arrangements. The Privy Council held that the section does not define the term agent And so agent just bears a perfectly standard common law meaning, a person who's authorised to act on the behalf of a principal and has the power to affect the legal position of the principal. In that case, HSBC had delegated the performance of its custody duties to Madoff Investments, who was therefore its agent. And so if Madoff Investments was doing conduct which would count as deliberate concealment, even if its principal was not, that would be enough to bring the claim within the scope of Section 32. So you can be a perfectly squeaky clean defendant, not do anything wrong, have a dodgy agent, or have a claimant who is the beneficiary of a claim in mistake, and still be subject to a claim which is of enormous antiquity because the claimant can rely on Section 32. We may feel that that overbalances the policy balance in favour of the claimant. We may not, but that is one of the quirks of Section 32 where we stand today. Thank you very much. And any questions for either of us?